We got a couple minutes, but is everyone here? Everyone's here. All right, we might as well go ahead and get started. Go on the record? Okay, we're on the record in case number 9722 in the matter of the application of Chesapeake Utilities Corporation, Sandpiper Energy, Inc., and Elkton Gas Company for a general increase in their natural gas rates and for approval of certain other changes to their natural gas tariffs. Council, we'll start with appearances. Council for the company.
Good morning, Judge Lawrence. Brian Quinn on behalf of the Joint Applicants. Once again, good morning, Judge Lawrence. Brian Quinn on behalf of the Joint Applicants.
Good morning.
Good morning, Your Honor. Ryan Shu on behalf of Office of People's Counsel.
Good morning.
Good morning, Your Honor. Michael Dean on behalf of the staff of the Public Service Commission. I also would like to enter the appearance of Harrison Scher and Ruthie
Herman.
Herman.
Good morning. So we're here on the evidentiary hearing in this case, some preliminary matters. I'd like to start with, I understand the parties have indicated that there is a settlement. For me to begin to evaluate a settlement, I need to understand and be clear on the parties' positions prior to settlement. So I have the comparison chart, and I had some questions. So the first thing I noticed was the depreciation study, line 4, the numbers didn't match staff witness Shea's testimony. Possibly the numbers match the exhibits in her testimony. Does anybody know about that issue? Okay, as with all of the issues we're going to talk about today, if you can't answer today, that's fine. I need to know how you plan to get back to me. There's no testimony on line item 4, depreciation study. Are the numbers changing based simply on ROE? Is there something else going on?
It would be my understanding that well, rather than say anything, I'll get back to you.
Okay. Then there's a line item 9, other gas expenses. Can anyone tell me what that is?
Your Honor, our witness, Joanna Ball, has the answer to that, and she's not here, but we will get back to you on other gas expenses.
Okay. There was an item discussed in testimony, underground gas storage. I didn't notice any company rebuttal. And then we still have numbers on the comparison chart. Just checking on that item. Company's not rebutting the OPC position on that, I take it?
That's correct.
Okay. There was testimony on Empower, and I do not see a line item on the comparison chart for Empower. I was wondering what happened to Empower.
I can answer that one, Your Honor. Empowered items are collected through a surcharge, so they would not be in the rate case.
Is the settlement agreement going to deal with the state of the testimony regarding Empower on this matter?
Yes, Your Honor.
So, TCPP, or I'm sorry, it's TCRR, which I guess on the comparison chart is CIS.
That's the technology cost recovery rider related to the CIS.
There's no numbers on the comparison chart.
That'll be dealt with in the settlement, Your Honor.
Disappearing. Next gen gas attributes.
That will be dealt with in the settlement, Your Honor. I can give you a hint if you want to hear it, or we can,
When am I going to see the settlement agreement?
hopefully by the end of this week. Absolutely by the end of this week.
And I see an adjustment on here for cash working capital, but I didn't see any testimony. Did I miss it?
Now, I believe the joint applicants discuss cash working capital, but
Can you
we'll get back.
tell me which witness? It's an adjustment proposed by staff, I believe, and I don't know which staff witness discussed it. Okay, so to recap, staff is going to get back to me on the depreciation study numbers and whether or not they match staff witness Shea's testimony, and clear that up and explain why the numbers are different between the parties and the status of that as of surrebuttal. Company's going to get back to me on what other gas expenses are, and the other parties can get back to me on that as well if they have information, as well as what happened to underground gas storage. Then Empower, CIS, next gen gas attributes are all going to be dealt with in the settlement agreement, explained in the settlement agreement, and then parties are going to get back to me on where in the testimony cash working capital is discussed, since it's on the comparison chart. Also, for the companies, I didn't see any rebuttal on estimated costs. Is that correct? They're not rebutting the position put forth. Line 18 looks like a staff position.
We'll confirm that as well, Your Honor.
Okay. As I said, I need to be
Estimated.
clear on the parties' positions prior to settlement so I can evaluate the settlement. I imagine the settlement's going to not have numbers for any of these items. It's just going to be one number. Yeah. Okay. This is more of a procedural. I think there were 2 adjustments for which OPC offered surrebuttal. However, OPC had not offered direct. Is that permissible? Does the company have a position on that?
I'll take a stab at it, Your Honor.
Probably not.
It often happens that further discovery results in items that were unclear at the time of direct testimony. And often there's topics that aren't even addressed in the original testimony of the company. And as a result, they're initially addressed in in rebuttal testimony of the company, and then the parties develop a position at that time. Often testimonies at the end of the testimony have statements saying that they reserve the right to modify their positions in later rounds of testimony.
And if I may, Your Honor, on those particular items, these, were items
You know
that
which items I'm talking about?
I believe it's the. Sorry, I've forgotten off the top of my
I
head.
can find it.
I believe it's the next gen gas and
Yes, Next Gen Gas is one of them. And it's
and then,
Mr. Dean, the staff took a position on direct. Companies filed rebuttal. And then not only did staff file surrebuttal, but then OPC picked up the thread on surrebuttal on that item, and I believe there was one other. If the company doesn't object,
Yeah, I was going to say, Your Honor, it's the classic direct testimony ending where the witness says, just because I didn't address anything doesn't mean I can't address it later, and it doesn't mean that I agree with it. I think
Okay.
that was all over certain witnesses' direct testimony.
okay.
We did not object.
Okay.
Thank you.
The joint application itself. At paragraph 8 reads, the companies make this joint application in accordance with Commission Letter Order dated July 18, 2022, which directed Maryland Division and Sandpiper to file a combined rate case by January 31, 2024. As part of the settlement agreement that led to the July 18, 2022 letter order, the companies agreed to file a combined rate case for Maryland Division, Sandpiper, and Elkton by January 31, 2024, and to include with its application separate accounting, cost of service studies, and rate designs for each of the companies. Pursuant to the agreement and as support for the rates proposed herein for Consolidated Maryland, this joint application includes separate accounting, cost of service studies, and rate designs for each of the companies, as well as for Consolidated Maryland. I have a copy of the June 27, 22 letter that requested and resulted in the July 18, 2022 letter order. At page 2, paragraph 3, one of the conditions agreed upon by the parties was that each gas company, Chesapeake, Sandpiper, and Elkton Gas, will file unique accounting, cost of service studies, and rate designs, open paren, i.e. not a consolidated rate structure for all companies, close paren. However, when you look at the testimony of both witness Christopher Redd and Joanna Baugh, Christopher Redd at page 9, line 15, aside from the permanent relief discussed above, the companies are also seeking to consolidate into one Maryland LDC with one tariff and one rate schedule. Similar testimony from Joanna Baugh. So it would seem to me that the joint application violates the agreement between the parties as documented in the June 27, 2022 letter, and by extension, it violates the Commission's July 18, 2022 letter order. Relatedly, the joint application claims that it includes separate accounting, cost of service studies, and rate designs for each of the companies. However, staff witness Coates' testimony, direct, page 6, states that the separate cost of service studies and rate design exhibits for each LDC are all based on CUC's proposed consolidated rate classes. So it would seem that the joint application again violates the agreement between the parties as documented in the June 27, 2022 letter, and by extension violates the Commission's July 18, 2022 letter order. My understanding of witness Thomas's testimony and his analysis of the proposed rate design is based on consolidated rate classes. There's no comparison to rates without consolidated rate classes, correct?
Your Honor, during discovery, I believe we provided additional evidence that compared individual rates for each of the 3 individual companies and a consolidated basis. And I'll also say this, the rates pursuant to the settlement agreement in this case, the rates are not going to be consolidated going forward, if that matters. But I'll address your other questions when you get to them. But I believe we filed individual cost of service studies for all 3 companies and combined.
You didn't file them, you provided them in discovery. And from what I understand, they were all based on uniform
I believe
rate
we filed them, Your
classifications.
Honor, but I will.
Okay, but they were all based on a uniform rate classifications. Right? The company already moved towards rate consolidation by having one set of rate classifications for all 3 companies, presupposing this was going to be approved. And so a full analysis couldn't be done because you'd already put in uniform rate classifications.
I disagree that a full analysis wasn't done in this case during the discovery process, but I will be prepared to support that.
Okay. Is the settlement agreement going to address what seems to me was an important element of the parties' agreement back in 2022, that this would not be filed as a consolidated rate structure?
Yes. I can address a little bit of that now,
Okay.
if you'd like.
And how it doesn't violate the commission's letter order?
I don't read the commission's letter order as prohibiting us from filing consolidated rate, Your Honor. I can cite to you 3 prior examples of gas companies filing rate consolidation requests with this commission over the last 30 years. They are regularly handled and approved by this commission.
In a rate case?
Yes.
When you told the commission you weren't going to file a rate consolidation?
I'm not sure we said, I disagree with the interpretation of that language, Your Honor, and I will say this, if I can finish. I will say that at the beginning, before we filed this rate case, we had a pre-filing meeting with staff and OPC where we discussed all the contours of what would be filed.
That's not the same as getting commission approval. The first page of the joint application indicates only that the companies request consolidation of the 3 tariffs into one unified tariff in anticipation of the companies combining their operations and assets into one LDC.
And again, we also filed individual class of service, and I will point to you where.
I understand that, but what I'm saying is the first page of the joint application gives me the distinct impression that you're going to do something in the future. And then the testimony goes ahead and requests it in this case. So this is not a rate case. This is a request for the 3 companies to become one company. But the caption, the first page, and the caption it's internally inconsistent. I don't think you've advised the commission. I don't know what you told staff, but I don't think you advised the commission of all the relief you're requesting by this, especially when the last they knew in 2022 you weren't going to do this.
I disagree with your reading of that letter. It doesn't prohibit a consolidated rate case, Your Honor.
The letter order is based directly on the request that was made that says you won't file for a rate consolidation.
Your Honor, I can only tell you what I assumed and what the commission understood when we filed. We were going to file 3 rate cases. This is a rate case. This is a rate increase. Every other rate consolidation request that the commission's handled in the last 30 years have took place within the context of a rate case.
I need those cases, please.
I can give them to you now if you'd like. Or I can send them to you. So case number 8281, Phase 2, Order 69009, dated November 5th, 1990.
69099.
I'll slow down. I'm sorry, Your Honor.
It's
Washington Gas. Washington Gas, let me give you the history here. So Washington Gas filed a rate case in 1990, and it was actually Frederick Gas filed a rate case in 1990. And in the context of that rate case, Frederick Gas asked to consolidate their rates with Maryland Natural Gas Division, which was, both were owned by Washington Gas. The commission said, we're not going to do that now. We're going to ask you to file a Phase 2 of this rate case where we will consider rate unification, rate consolidation between Maryland Natural Gas and Frederick Gas. So in case number 8281, Phase 2, order number 69009, dated November 5th, 1990, the Commission consolidated the rates of Frederick Natural Gas and Frederick Gas Company and Maryland Natural Gas Company.
In a phase
Specifically,
two?
they allowed Frederick Gas to adopt the rates and rate schedules of Maryland Natural Gas
In phase 2. you said.
in Phase 2.
After phase 1 was the rate case, and phase 2
yep.
was the consolidation?
And Phase 1, they expressly directed Frederick Gas to file both individual and consolidated cost of service studies. Following the order 69009, a couple of years later, WGL filed a combined rate case for Frederick Natural Gas and Maryland Natural Gas. That's case number 8545, order number 70658, dated July 29th, 1993, where an intervener argued that the rate consolidation that was agreed to in the prior Phase 2 case somehow was unreasonable and provided an unreasonable study to Frederick Gas, an unreasonable subsidy by Maryland Natural Gas Companies to Frederick Natural Gas Companies. It was AOBA in that case. And the Commission said they looked at the docket and the evidence in their prior Phase 2 case and looked at it again in that rate case and said there were no undue unreasonable prejudice and the rate was just and reasonable. So that's Washington Gas. I can go to Chesapeake and I can go to Columbia when you're ready.
Okay.
So Chesapeake, we have an example right here involving Chesapeake. Case number 8643, order number 71464, dated September 17th, 1994, the Commission approved the consolidation of Citizens Gas Division with Cambridge Gas. Both were divisions of Chesapeake. In that case, Chesapeake, in the case prior to that, Chesapeake asked for the divisions to be consolidated, and the Commission said, staff asked for individual and consolidated cost of service studies. Those were provided, and then the Commission approved the consolidation.
8643 is captioned in the matter of the application of Chesapeake Utilities Corporation, Citizens Gas Division, and Cambridge Gas Division for authority to consolidate for the purpose of rates and regulation.
Yeah. Yep.
They asked for consolidation.
Yeah, it doesn't have to be in the context of a rate case, Your Honor. I'm not sure there's any requirement either or. I'm just expressing.
No, I'm actually thinking that it should be a separate proceeding.
This is that proceeding.
This is a rate case we're in.
It's not like, as I said, this is a rate case where we provided data because we had to support individual cost of service in individual separate plants and consolidated rate base. So this is I don't think there's any prohibition for having a consolidation within the context of a rate case.
That's my question.
There isn't.
And that I need support for that.
Okay.
You showed me cases where they asked for consolidation. That's great. But I need to know that you can ask for consolidation within a rate case after you said you weren't going to, and when the caption doesn't make it clear what you're doing,
okay.
and even the first page doesn't make it clear what you're doing, but then it's slipped in. And then the analysis is all based on getting partway there. In other words, I didn't see an analysis of each individual company with their existing rate classifications. I saw new rate classifications. We've already gone down the road towards consolidating, and I don't know that that is proper because you didn't first ask, can we consolidate? And you didn't come to the Commission with any of the 6105 factors.
This is not a 6105 case, and I'll address that if you'd like me to as well. But, Your Honor, I'm not sure I'd use the phrase we slipped this in. I think everyone, as I said, the Commission and the parties in this case knew what this case was.
The Commission. How did the Commission know?
Because we told them.
Who'd you tell?
We told them during the hearing when we were asking to move the required filing dates around. I can
You're talking about in 2022?
Yeah, yes.
I have your letter.
The commission was aware that we were going to file a consolidated case and request 3 rate cases at once and request consolidation.
No, I strongly disagree. Paragraph 3
And
of page 2 of your letter says not a consolidated rate structure.
By that, they meant you're going to also file individual cost of service studies and be prepared to address the, Your Honor, in any case, the commission can approve or reject a request. So we were presenting the case supporting our request in a way that supported our request. If you read that as assuming it would be approved, that's our advocacy in the case, number one. Number two, this case, the settlement agreement we just reached, is not consolidating rates or tariffs in this case. It will not be a rate.
And I wouldn't know that because
I
I
understand
didn't
that.
receive a written agreement before this hearing.
And Your Honor, I wanted to get you that written agreement for today. We'll get it for you. That's why we extended the procedural schedule, and we'll get it to you by the end of this week. But I understand your question. It's not, I'll do my best to answer any other questions you have.
Mr. Dean's email said consolidated rates, the one he sent me last week.
The settlement agreement in this, let me be clear. The settlement agreement we just reached in this case will result in individual rates for all 3 companies and individual tariffs for all 3 companies. They may have some charges in common, they may have some terms and conditions in common, but that's what the settlement agreement will result in this case. I'm not aware of any prohibition between filing a rate case that includes a consolidation request or vice versa. The third example I can give you is a Columbia Gas example.
What's that case?
All right, so Columbia Gas actually consolidated their rates at an admin meeting in 2000. After Columbia Gas is, actually, as you may know, Your Honors, really 2 systems. It's the Allegheny and Cumberland system out in Cumberland, and then 65 miles away, there's the Hagerstown system. Columbia Gas acquired Allegheny back in '61, Hagerstown in '68, and had always filed consolidated cases, rate cases for those companies. In March, ML number 70973, filed on March 1st, 2000, Columbia filed revised pages to consolidate their tariffs, and that was consolidation of the tariffs for Allegheny and Hagerstown. Revised their line extension, introduced propane service, and make textual changes to their tariff. That was in between rate cases. The commission, I believe, approved that at an admin meeting. I don't have those documents in front of me. I was asking the commission over the weekend to get them. I'll get them to you as soon as I can. But the commission approved those consolidated rates on effective May 24th, 2000, in ML 72619. So the Washington Gas and Columbia Gas examples are directly on point. Those are examples of companies that already owned these gas companies, and then pursuant to internal reorganizations, economies of scale, all the benefits that we've demonstrated in this case that will inure to customers, the companies decided to consolidate those operations.
Where did you demonstrate that?
In this case.
No, I know. Specifically, where?
There's testimony in this case. You're going to see it in the settlement agreement testimony.
Because what I saw in the testimony that I read, it was very conclusory. And again, it already supposed that this was, it presumed this was approved.
It's our job to put evidence in front of you, Your Honor, that I disagree that this case, anything I filed in this case assumed any approval. But there was data requests back and forth. There was staff testimony by Ms. Coates. There was testimony, I think, by OPC's witness, didn't object to consolidation the way that.
Yeah, and I don't understand that.
Okay. But I'm just.
I don't
that's
understand
a question
why. I don't understand OPC's witness's testimony.
Okay.
Seems to collapse. The witness Coates is very clear in outlining what you can consolidate when, and your witness just collapses them into one simple analysis. I don't get it. I don't understand why OPC doesn't have a problem with the cross-subsidization, why it doesn't have a problem with one company paying cost of service of another company. But
Your Honor, I'll be prepared to address that if you'd like to. Rate base is, there's plenty of examples. I can give you 10 to 15 if you'd like, that don't require the commission to follow one particular model or method for determining rate base. Maryland's a fair value state. So in this case, the rate base of all three individual companies were reviewed, and we reached a settlement in which all parties agree there was no unreasonable cross-subsidization between the entities. We're going to have to put...
Try to understand what I'm saying. I understand there's testimony saying that they didn't find it to be unreasonable, but where's... Again, you've already started down the path. You've presented them with something that's presumed to already be approved, and so they're providing testimony on whether it's reasonable or not. But where's even the justification in the first instance?
We have witness testimony of Red. We have additional witness testimony, I think, in our rebuttal about, we had several DRs that discuss all the benefits of consolidation that I obviously will now attach to our settlement testimony.
But in order to evaluate the benefits of consolidation, don't you need to see what it looks like without consolidation, without already having moved to the same rate classifications?
I think that you're going to see in the settlement, you're going to see a comparison between existing rates and rates after this case.
Okay, first paragraph of Mr. Dean's filing from August 8th. The last line says, the parties hereby respectfully request that the current procedural schedule be suspended to provide the parties with sufficient time to reduce the settlement and the resulting consolidated tariffs to writing. So that's what I took to mean. We were consolidating everything and approving the consolidation.
Well, again...
It's just the tariffs, not the rates.
Yep. Again, apologies for not being clear or in whatever you understood it to be, but I can tell you that's the result of this case.
I just want to make sure that
Yes.
I do need support for the commission being able to approve a consolidation in the middle of a rate case. I need support for why the parties don't think the company violated. Again, I would suggest you reread page 2 of the June 27, 22 letter that you signed.
Yep.
And paragraph 3.
Your
And
Honor, I don't read that letter as prohibiting anything, and I think it's a hyper-technical reading to...
You keep saying that, but it says, we note that the companies, staff, and OPC have agreed to delay and synchronize the upcoming rate cases for Sandpiper and Chesapeake, subject to the following conditions. It's a condition of the agreement that each gas company will not file a consolidated rate structure.
And what that meant, Your Honor, respectfully, is they were going to file 3 separate cost of service studies, everything we did in this case, consolidated and separate. I'll point out where those are in the record and deal with that if you'd like. So, understood.
My understanding
And
of
what's-
witness Coates' testimony is that that was done partially. Let's see. Yeah, top. Her answer to the question on bottom of page 5. Do you agree that CUC complied with the requirements described above? A, answer, partially. The corporation filed separate cost of service studies and rate design exhibits for each LDC. However, those exhibits are all based on CUC's proposed consolidated rate classes. This means that the cost of service studies and rate designs filed in this case cannot be directly compared with each LDC's current or previous cost of service studies or rates. Should the Commission reject CUC's proposed customer classes for any of the LDCs, the cost of service studies filed by the CUC could not be used to determine appropriate rates for the existing rate classes. Thus, while CUC filed separate cost of service studies and rate designs for each LDC as ordered, those cost of service studies and rate designs are based on proposed consolidated rate classes which lack commission approval. That's what I read from witness Coates' testimony, and I don't know where the analysis was done. If you provided something in here in response to this testimony, I don't have that anywhere.
Understood. We'll
Okay.
point out where it is in the evidence.
My understanding from this testimony and witness Thomas's testimony is they're then left with evaluating something based on the company already heading down the road of consolidation because you have the same rate classes. And there's nothing comparing if you didn't have the same rate classes, if you still had the existing rate classes.
Understand your
So I don't see, it still seems to me that you've skipped a step of the commission approving the consolidated rate classes.
Well, that's what we hope to rectify in this case, and I'll point into the evidence where that data exists.
Does the settlement agreement address public comments filed in this case?
Does it address public comments filed in this case?
Yes.
I'm not aware of any public comments filed, but we can address it. The
Do you
settlement
know how
agreement
to
is.
find the public comments filed in this case? Do
Sorry?
you know how to search for them and find them on the commission website?
I haven't seen any public comments in this rate.
Okay, well, there's a number of public comments filed, and one of the things that I sometimes do at an evidentiary hearing is request whether, or inquire into whether the company and the parties have addressed public comments. And since this is perhaps a settlement, I don't want to wait until the settlement hearing to ask if you have had a chance to address any of these comments. And so then I was asking if the settlement was going to address them. You might want to take a look at the comments, because there are some comments regarding executive compensation and a $2.5 million bonus paid to the CEO of Chesapeake Utilities Corporation, and a comment about the operating income of the company you might want to take a look at. Comment about CUC's profits and recent acquisition of Florida City Gas with a cash payment, and resulting increases in operating income, I guess. And a question about not understanding increases in cost for Sandpiper because of its access to a recently constructed pipeline and price stability. There's also a comment regarding how Elkton Gas is now owned by Chesapeake, and someone having issue with billing readability and poor customer service. So, I'm sure someone from staff can show you how to search public comments on our website if you need to look at those. I'm hoping that the settlement addresses those to the extent necessary. All right. You've given me some cases. Did you want to, and I can look these up, did you want to brief this?
If you'd like me to, Your Honor. I have them, and I have them with me today, but I can brief it if you'd like. I'll
the other
proceed however
parties-
you'd like. I could send you an email, whatever you'd like me to do.
The other parties want to brief the issues raised today with regard to the,
Your Honor, if I may, would you like to re-express the issue? Would you like us to wait for an email and we can?
no, I'm not going to send an email. Mr.
Yep.
Dean, don't ask me to put what I've said today
Okay.
in writing.
I
This
got
is being recorded. Do you know how to access the public utility law?
Absolutely, just asking. Secondly, Your Honor, I didn't mean to interrupt. Please finish.
No, go ahead.
You asked about 6105. Would you like me to address that in a brief?
You can. I'm not saying this has to be filed under 6105. It's more of the factors under 6105. G2, the factors that the commission would consider are
Yeah.
the types of factors that I would think the commission would consider if they were presented with a request to consolidate.
Yeah.
And since this wasn't presented as a request to consolidate, I need to know why you think that we don't need to have evidence on these factors.
Yeah. So, a couple things. This is essentially an internal consolidation of companies that are commonly owned. This is not an example of an acquisition of one public utility by another person.
I understand all that. I guess my problem is that there's still something happening here that seems to me requires commission approval.
Absolutely.
And it seems to me that, again, my interpretation of the first page of the joint application is it was going to happen subsequent to this.
What was going to happen subsequent to this?
A request for consolidation. A formal request for consolidation was going to happen.
That's essentially how this is mapped out now, Your Honor, because we're not consolidating rates in this case.
Okay.
Let me be clear.
All right. So
subsequent.
You don't need to brief then if you're not going to consolidate. If you're not going to do what I thought you were trying to do,
yeah.
then you don't need to brief why you can't do it.
Yeah. And Your Honor, I understand completely your reading. You read the testimony application correct. Again, that's why I apologize for not getting a settlement agreement before today. But I think a lot of these questions will be answered in the settlement agreement, number one.
And if they're not, then you can go ahead and brief.
I think I understand.
Okay.
Some. Yeah, that's what so we'll point to the discussions we had amongst the parties about how to design rates and what went into all of those calculations. All of that is in this case, and all of that is going to be captured as a result of the settlement. Okay. I read you loud and clear. We'll have to be very specific and explain how all that was done. So, if I may, just to review, so I think, to be clear, we're not consolidating rates in this case. This is a rate case, but there's no prohibition to do both at the same time, quite frankly. In those cases that I provided, I think the rate consolidation in the Washington, maybe I'll quit while I'm ahead, Your Honor. You can read them. You're going to read them yourself. So it was a phase 2 of a rate case that initially that happened literally a month after.
I don't know that it's improper,
yeah.
so long as it's clear what's being requested.
And that's what I was going to say to you as well, Your Honor. No one's trying to hide the ball here. Anything, if there's a concern about 6105G, but I don't think there is. I mean, there's all of that.
I found the testimony a little light.
Yeah.
Very conclusory.
Yeah. Your Honor, we will address all that and support it with evidence in the record in the settlement testimony. Okay. So I'll stop there.
And then,
sorry for going on.
If the parties want to address why something that appeared to be a condition in an agreement they had 2 years ago is no longer important, that's fine.
Your Honor, I think you're framing it in a way that I don't know if it's exactly fair. The company can ask at any time to do anything, okay? And I think the fact that we asked for a consolidation in this case, but also filed individual cost of service and left up to how this case progressed, and we had 61 rounds of discovery, 500 DRs in this case, an extra 5 months of review. This was all done with the understanding that this was going to be a big case that had a lot going on with it. All of this is in front of the commission now, and no one's trying to hide or sneak in anything. All the discovery was based on individual company numbers, consolidated numbers, and every party in this case
Well, I
said
saw all
we had
that with
61
respect to
rounds.
the accounting. The accounting, I see the separate companies and the consolidated. It's all pretty evident until you get to the rate design, where the analysis isn't there for me to see.
Okay.
The response to witness Coates' testimony hasn't been explained to me sufficiently to understand how that got cured.
Thank you, Your Honor.
Okay. So you still owe me some things, Mr. Dean? And
I owe you some things.
regarding the comparison chart
Comparison chart.
that you can send. Well, if the comparison chart needs any revisions, that has to be filed. If the testimony needs any revisions, that needs to be filed. But if it's just merely explaining something, that can be by email. Okay. Anybody have any questions? I'm not going to write this down for you, Mr. Dean. You can watch this. I've been very careful to be close to the mic. You can watch the video. Okay.
How quickly can we get a transcript of today's proceedings?
If you, you can make arrangements with him.
I'm kidding, Your Honor.
Okay.
Thank you.
But you should be able to listen to it, and you can hit the pause button and take notes, and yeah. All right. But if anybody has any questions, it's your chance to speak up.
So we're going to file the settlement agreement and then potential briefing
Oh yeah,
afterwards.
that's right. You owe me a date. You're not getting this to me until the end of the week? Is that what I heard?
I didn't hear what you said, Your Honor. What?
You said you're not getting me a settlement agreement until the end of the week.
Not getting it to you until the end of the week?
That's what you said.
I'll try to get it to you
I
before.
said there was Friday was discussed, then there was Wednesday was discussed, and now
Yep, and then I thought we had the understanding we didn't have to have it today.
that's
Thank
yeah,
you.
that's
All right.
fine. But I thought the default, the last possible day was Wednesday, from Mr. Dean's
Your Honor,
original request.
I can commit to getting you the settlement agreement by Wednesday, but I can't speak for OPC or staff.
Wednesday, Mr. Shu?
Yeah, we have a draft of it, and I was going to send it to staff and OPC today, later today. And if that helps shape their...
Do you see any issues with getting a settlement agreement by close of business Wednesday?
I can say we will try to get an approval of the settlement agreement. It's hard for me to agree to something I have not seen the text yet, and we tend to review the text of settlement agreements very diligently, I guess.
I hope you
would
have
be the
all that
word.
standard language at the end that I love about how if I don't agree to every single term, it's null and void. It's my favorite. You won't leave that out, right? Just kidding. Okay, so we're shooting for Wednesday, hopefully. It might slip to Thursday. When are we thinking about coming back for a hearing on the settlement?
So, Your Honor, I was hoping we could come back the last week of August. Next week, I'm out of town. So I was going to propose, and I have witness availability for the August 26th, the week of August 26th.
Okay.
But I have not discussed that with staff and OPC. I've only discussed it with my witnesses.
Let's see what we have going on here.
Staff's only request would be that it not be on a Monday.
Not be on a Monday? Oh,
Your Honor, if you need OPC's witnesses, our witnesses are not particularly available that week.
not particularly available that week.
Basically,
Is that what you said?
Yeah. Essentially, most of them aren't
Like not
available
on
that week.
August 29th?
No. Our main rate design our main revenue requirement witness is only available on Monday the 26th. Rate design witness only on the 29th and the 30th.
The 26th, 27th, and 28th are also dates that the Maryland Water rate
exactly.
case is
Yeah.
ongoing.
I do. I see that. That reminds me, though, Mr. Shu. How did I forget? Mr. Myers,
Mm-hmm.
surrebuttal. That's why. He doesn't have figures because it's being taken care of in some sort of rider. I thought staff had a problem with the rider.
Your Honor, the rider's out. It's part of settlement. I'll give you that
Okay.
preview right now.
So there's no riders, but there's also no numbers then? I thought there was an alternative. It could be in rate base or it could be in a rider.
That will be explained in the settlement agreement.
Okay, so the lack of numbers in the comparison chart will make sense to me?
Yes?
Okay. I'm sorry, back to you. You said one is available on Monday the 26th and one is available on the 29th? Which one's available on the 29th?
Mearswa, our rate design witness.
You're available all week?
Yes.
Oh.
You just don't want it Monday, Tuesday, Wednesday because of Maryland Water.
Sorry, Your Honor. Our rate design witness, I'm not exactly sure. Apparently got into a bike accident and
I feel like I've
cracked
heard
his
that one before.
skull, and I'm not really sure what his availability is now anymore.
Jerry?
Yeah.
If we were to look to the first week in September, right after Labor Day, right? Everyone's back in on Tuesday the 3rd. How's everyone feel about Tuesday, September 3rd?
I prefer Wednesday, but could make it work. I have to cancel some.
Sorry, Your Honor. I haven't actually pulled my witnesses on September, so I'd have to get back to you.
I'm sorry, what did you say about Wednesday? Or, Mr. Quinn, what did you say about?
I was just saying I have a hearing on Tuesday the 3rd, but I can have someone cover that for me. And Your Honor, may I ask a question?
Sure.
We will have submitted the settlement agreement and testimony in support from certain witnesses. Are you thinking you would want to have only the witnesses that filed settlement testimony and support, or do you need all 12 on call?
Yeah, it's a little
I
difficult
understand.
because
Yes.
I need to see the settlement
Yes.
agreement.
Yes. Okay. Thank you. Understood.
Wednesday the 4th doesn't look good. I'm sorry, whoever said Wednesday. There's a few
Okay.
things going on there. Well, we could maybe do noon on Wednesday the 4th.
Or the 5th. Wednesday the 4th.
At noon?
I'm going to have to also check. I got to
Okay.
check witnesses. Your Honor, I apologize. We had our witnesses
For
targeted
August.
for the August 26th week.
Yeah, well, that would be my preference.
So we're still in the August 26th.
Okay. Why don't we? Is there? Okay. I was going to fit in after your transportation thing. Okay.
Could always have 2 days.
Back to the 29th. Staff have any issue with the 29th?
I don't believe so.
Okay. Your co-counsel is nodding her head and putting a thumbs up.
Uh,
Okay. What?
Thursday the 29th.
Thursday the 29th.
OPC's revenue requirement witness won't be available, but
And that's too bad, yes.
Yeah.
But, we could keep going here until December. So, Judge Grace just offered to move her 2 hearings that are at 10 and 11, but I think we can handle it. We start at 1. We should get done, right? 1 p.m. on the 29th? Yeah? Or do you want to start at noon?
Whatever you say, Your Honor.
Why don't we start at noon? That way we'll be sure to be done at a decent hour. Okay, noon on the 29th.
In person.
Yeah.
Yep.
Don't you think this has been good?
Yes, it has. I just meant if a witness can only make it virtual,
Oh.
I will get in touch with you before then.
Yeah. It doesn't work
Understood.
really well in here.
That's the answer.
It's like worst case scenario. So, right? I mean, I can try to do it, but it's a nightmare.
I've seen that firsthand.
Yeah. Okay. All right. Anything else? When are you going to get me answers on the comparison chart?
As soon as possible. I assume no later than when we file the settlement agreement.
Okay. Anything else?
Would you like all your answers at once, or I owe you a couple answers on the comparison chart too. I don't want to make things any more confusing.
Yeah, one filing is fine, or one submission is fine.
All right. Thank you.
All right. Anything else, Mr. Shu? I want you to have every opportunity to ask every question
No, Your Honor.
that you have. Anyone else have any questions? Okay. We can go off the record. We're adjourned. Thank you.
Thank you.
Thank you.